Be seated. We will call up next the case of Shorter v. State. Counsel for the appellant may proceed.
May it please the Court. Michael Ufferman on behalf of Mr. Shorter. I'd like to reserve 5 minutes of my time for rebuttal. The issue in this case is whether the trial court erred by allowing the state and the state's witnesses to inform the jury that my client was a member of the 773 Boys. In making my argument, I've relied extensively on Judge Taylor's opinion in the Martin case. And in Martin, Judge Taylor explained that evidence identifying a defendant as a member of a gang may result in prejudice because juries tend to associate such groups with criminal and violent activity.
But your client wasn't identified as a member of a gang, though, was he?
He was identified as being a member of the 773 Boys.
Well, someone would have to know that was a gang, I guess, for you to come within this dissenting opinion that you're relying on.
I think it was obvious from the context in this case. I think the fact that the prosecutor in opening statement said that this was a turf war between groups and my client's group was the 773 Boys, I submit would allow any reasonable juror to understand that that means that the prosecutor is letting them know that the 773 Boys are a gang.
Well, there could be a turf war between the Chamber of Commerce and Associated Industries. That doesn't mean either one of them are breaking the law. I mean, this is not exactly the same thing as identifying your client as a member of the Crips or the Bloods, is it?
Oh, I think it is. I think it's clear in the context of this case that the 773 Boys were the group in this particular small county that was the gang that controlled this particular area of turf, and no one came close to them. So unlike a turf war between the Chamber of Commerce and some other group and the disagreement...
Yeah, but isn't the problem with identifying someone as a member of a gang is having the jury believe because they are engaged in all these other criminal activities that they did this crime?
Yes, that's exactly it.
But apparently these people weren't engaged in any criminal activity. They just, had their part of the neighborhood they hung out in, and the other people hung out at the other end of the street.
Well, I think that's exactly right, too. And I think Judge Bateman, the trial judge below, acknowledged that this does not appear to be gang-related, and therefore there is no probative value of allowing in the fact that he's a member of the 773 Boys. But nevertheless...
Wasn't it necessary, though, for the state to establish that there was a threat made against another group because the victim was a member of that group, and how else would the crime have been explained?
Well, I don't know if it's that group, but yes, no, I agree that the state had a right to establish a motive in this case, and I think Judge Taylor addresses that as well. He says that you have to do a balancing test, weigh the probative value versus the prejudicial impact.
Judge Taylor's a she, but go ahead.
Oh, thank you for correcting me, and I apologize to Judge Taylor. Judge Taylor pointed that out in her dissent, and she explained that before the prosecutor began his inquiries into the witnesses, all of the defense witnesses had acknowledged that they were close friends and neighbors of appellant. Thus, a suggestion that appellant and witnesses were also members of a gang was cumulative and added little to further the prosecution's objective. That can be said here. That's exactly what... imagine this case had the prosecutor simply got up and said there was a fight between Mr. Shorter and his friends on this particular evening, April 24th, 2001. And during that fight, Mr. Shorter said, I'm going to get my gun and I'm going to get these guys. And then the other witnesses established that later in the evening they saw Mr. Shorter approach the victim's house, but nothing ultimately occurred. And then what we know after that is the next day someone claims that they saw my client and one of his friends in the vicinity of where the alleged victim's house was. My client presented an alibi witness who said that he was not there, and we have no other evidence tying Mr. Shorter to the crime. The fact that and you could stop right there, and you could say that the reason and the motive for this is, yes, they got into a fight the night before, and Mr. Shorter was trying to get revenge. And in fact, the evidence shows that he said, I'm going to go get revenge. That would have been enough to go on top of that and say, and...
So that would have been all right.
Well,
but the problem here is giving them the label, the 773.
That's exactly right. And why is that label being given? And Judge Taylor, in her dissenting opinion, explained that gang affiliation is presumptively prejudicial, and juries know that gangs are inherently dangerous, and they may improperly convict the defendant on inferences that because the defendant was a member of this gang, the defendant has a criminal disposition.
But again, the word gang was not used.
Correct.
And I don't recall seeing any other evidence that was brought out that described any criminal activities by this group of youngsters who call themselves the 773 Boys. So is it just the fact that this group gave itself a name and that piece of evidence came in, that's the problem? Just the fact that they named themselves is enough to infer or to imply to a jury that this was a criminal gang?
Why did the prosecutor need to get it in? There's no other reason other than this is a close case, and the prosecutor knew that that added information planted in the back of the jurors' minds that he's a member of the 773 Boys, a local gang that everyone's familiar with. That's why he must have done this.
Well, again, you keep using the word gang, and that term wasn't used. I mean, gang says something.
773 Boys says something.
Doesn't say anything.
What does it say? What does it say? What does it say that, for example, Backstreet Boys doesn't say? What does it say?
Well, it wasn't that these were members, local musicians that like to hang out in someone's garage and play guitars.
Well, how does the jury know that? I mean,
but he said in an opening statement, this is a group of boys. They're territorial. They hang out on one side of the city. The other friends hang out on the other side. And when they come in contact, it's a turf war. And this group identified themselves as 773 Boys. I mean, what could be the purpose of asking the jailhouse snitch, did the defendant have a tattoo on his arm, and what was that tattoo? The 773 Boys. Repeatedly, the prosecutor's trying to plant this idea in the back of the minds of the jurors that he's a member of a gang. Because, again, this is a close case. There is no physical evidence whatsoever. There's no eyewitnesses. It comes down to the believability of, do you think just because there was a fight the night before, and do you think that just because someone's claiming that he was in the vicinity, but an alibi witness says that he was not, is he guilty? And then we have these two jailhouse snitches that, of course, have their own reasons for testifying.
What is the significance of the fight before if you don't get into the fact that there were two groups of people and one person in one group threatening the entire other group? What is the significance of that fight?
Well, I think,
in other words, in order to get to the significance, you have to say that there were these two groups of people, don't you?
True. Well, and I think the judge said that. I mean, I quoted this in my brief. The judge said when this issue was addressed at the beginning of the trial, stop, prosecutor, stop. You just described the incident without having to put a label on it. Why do you need a label? And the prosecutor went on to say that, well, because this is, we all know this is the gang in the local community, and this is a turf war, and they did this because it was the gang.
You'd have a better case if Judge Bateman let the prosecutor do what he wanted to do, wouldn't you?
Sure.
Well, he really did put the brakes on the prosecutor, it seems to me.
Well, he said he was going to. He said, why do you need to get to the label? It's too prejudicial. Those were his words. And then he changed course and said, I'll let you get into it a little bit. And he would always, the prosecutor would say, what did this group refer to themselves as? The 773 Boys. Objection, Your Honor. Stop. Overruled, but move on. So it came out 3 different times with the witnesses, came out with another witness about the turf war. Why does it need to come in? It's a close case. It's enough to say, yes, there was this fight. Yes, this group was in a fight with this group. And yes, Mr. Shorter allegedly made these comments that he was going to go and respond to this. Stop right there. Why are they putting the label on it? Because they know that the label in the back of the minds of the jurors tells them, yes, he's not using the word gang, but they're the 773 Boys. That is a gang.
You don't? I'm sorry, go ahead.
So let's take out, let's pretend like 773 Boys didn't, that term wasn't included. So the evidence basically shows there was a fight between two neighborhood groups. The defendant was involved in the fight, as was the victim. The defendant was heard threatening to kill the other group that included the victim.
Yes, Your Honor.
He and his co-defendant and others went to the victim's house with guns the night of the fight.
Yes, but nothing happened.
Nothing happened that night. They were seen the next morning in the vicinity of the victim's home.
Correct.
10 minutes later, shots rang out, and the victim was found dead on somebody's porch.
Correct.
Why is the term 773 Boys so critical? Isn't that evidence enough to have convinced a jury that the defendant was guilty here?
Well, let me answer that in 2 ways. Yes, I agree that the state didn't need 773 Boys to establish their case. And I think the only reason, so knowing that, you have to ask yourself, why did they insist adamant at the beginning of the case, adamant, first words out of their mouth in opening statement, we need to tell the jury these are people, or Mr. Shorter is a member of the 773 boys. Why did they want that? You have to assume they wanted it because they knew it was prejudicial. But then beyond that, if you're asking me, is it a harmless error issue? My answer is no, it's not harmless, because it is a close case. Given all those facts you just said, I'm not arguing there's not prima facie evidence that maybe even would survive a judgment of acquittal, but this is still a very close case. Mr. Shorter himself put on alibi witnesses that said that he wasn't anywhere near the scene at the time. So what, at the end of the day, it comes down to credibility, circumstantial evidence. It's clearly no direct evidence whatsoever, no physical evidence, no eyewitnesses. So it's a close enough case that if the court determines that it was error to allow the 773 boys references to come in, it cannot be considered harmless. And again, I ask the same question. Why would the prosecutor want to put this in? They had their case. They were able to establish their motive. The only reason the prosecutor would have wanted to let the jury know repeatedly that Mr. Shorter was a member of the 773 boys is because he knew what impact that would have on the jury. I'll reserve the rest of my time for rebuttal.
May it please the Court. Meredith Carbula, attorney for the Appellee Attorney General. Why was the evidence admitted? Because it's relevant to motive. The state has the right to put in evidence that explains the crime, explains why the crime was committed. The reason why this crime was committed, in fact, the state submits that the prosecutor could have opened his opening statement was this was a gang-related shooting. He didn't, however. He limited the evidence in accordance with the admonition of the court to 773 boys. And I think it's somewhat ironic that the appellant says everyone knew it was a gang. The jury must have known this was a gang, the 773 boys. Everyone knew it in this small community. Well, Jemiah Swain, who was the first witness out of the box, was asked by the prosecutor whether the Shorter's group went by any particular name. He said, I don't know. I just know they're friends and family. I don't know whether they're call themselves the 773 boys. So any notion that everyone knew is rebutted by Jemiah Swain, who was, by the way, a member of the victims group. And the prosecutor admitted that Mr. Green was a member of a group and Mr. Shorter was a member of a group.
But they didn't have a name, I guess?
No evidence came out whether they had a name. But, the prosecutor acknowledged right up front that this is a gang, that this is a shooting that was between one group and another group. And this one group called themselves the 773 boys. Now, on page 16 of the appellant's brief, I think he tries to argue that the prosecutor went beyond what was relevant in this case. I mean, the trial court was a little wishy-washy in his ruling initially about, well, yes, no, I'm not going to let it in. It seems prejudicial. I'll let it in if it's relevant. And that's why the defense counsel was objecting, because there wasn't a definitive ruling. But the first witness out of the box, Jemiah Swain, says, I don't know what they call themselves. And on page 16 of the appellant's brief, he says that the record is replete with this. And one of those things, he says that the jury was told by Jemiah Swain that the defendant was a member of the 773 boys was a question by the prosecutor posed to Jemiah Swain of, do you know whether they refer to themselves as 773 boys? That was done outside the hearing of the jury. It was done on a proffer. That's on page 80 of the record. This other testimony of Carlos Cobb, who testified that, this was a turf thing. We stayed down here, they stayed up there, and we didn't, never the twain shall meet. That was not objected to. So any notion that the record is replete with these references is not true. The word gang was never used. The prosecutor never referred to Shorter's group as the 773 boys in closing. The only time this came before the jury was one time through Carlos Cobb. He testified that Shorter's group was called the 773 boys. And one time when Craig Stevens testified, and that was really identity. Craig Stevens had not known Mr. Shorter prior to being in jail with him. Mr. Stevens testified that Shorter made a comment during an altercation with another inmate that, I've killed before, and I'll kill again, or I don't have a problem doing it again. And when asked whether he had any tattoos, and this was for identification, he said 77 and some other number. It wasn't 773 boys. It was 77 and some other number. So any notion that objected to comments are replete through the record is simply not true. I think you have to look, obviously Judge Padovano, it's great to rely on Judge Taylor, because she's speaking in sort of broad terms. But of course, it's the dissent. In Martin case, the court found that it was relevant. And of course, that had to do with motive to lie on the part of witnesses, that the gang membership of the witnesses and the defendant were relevant to show that the witnesses had a motive to lie. But if you look at the La Flupe case out of the 3rd DCA, the court said that gang membership was relevant even though they did not refer to the zombie boys, that's in La Flupe, as a gang. They did refer to them as zombie boys. The 3rd DCA said that was perfectly proper because it showed a motive for the killing. That is, it was retaliation for the shooting of another zombie boy. And that's exactly what we have here.
Your argument, if I understand it, is that had the trial judge allowed that, this should have been upheld, even that.
Absolutely.
In this case, because it was relevant to show the significance of the threat.
Exactly. And in fact, in the Evans case, in which the appellant relies in part, the Florida Supreme Court said that the evidence of gang membership wasn't particularly relevant because in Evans, the defendant killed a member of his own gang when Mr. Lewis, there was a decedent in that case, they all had a plan to go rob a dope dealer, and Mr. Lewis drove them down and then took off in the getaway car. And Mr. Evans believed that Mr. Lewis was going to steal his money. So they laid in wait and they ambushed him and executed him. And the Florida Supreme Court said in that case that evidence of gang membership wasn't relevant because the state had sought to introduce that evidence to show how Mr. Lewis and Mr. Evans knew each other, and that wasn't at issue. However, interestingly enough, in Evans, the Florida Supreme Court said that evidence that they intended to go down and rob a dope dealer was admissible. Why? Motive. And that's exactly what we have here. Evidence there's no way to explain this. Why would a person get upset because there was a fight? It was a fist fight. There was no guns, no clubs, no rocks, no bottles. Why would a normal person get upset to the point they're going to go down and ambush and execute another member who was in this fight? And the only way to explain that is to show that this group, the 773 boys, had been disrespected by Mr. Shorter and his group, or Mr. Green and his group, when they went up. Because, Judge Marsteller, you had the facts down absolutely perfectly, except one small addition. What had happened prior to the fight up at the top of the hole was there was another fight involving Carlos Cobb and a member of the 773 boys that happened down on a local, one of the local streets, sort of, I guess, in neutral territory. And after that fight, Mr. Green and Mr. Cobb went down and got Jemiah Swain and Cornelius Cobb, and they all went up to the top of the hole to confront the 773 boys. And that's the fight that resulted in Mr. Shorter threatening to get a gun and to come down and kill Mr. Green, and that's exactly what he did. There's no way really to explain that of why in the world this would be such a big deal without this evidence. And again, the prosecutor strictly limited it to what was relevant. Motive through Mr. Cobb, identity through Mr. Stevens, and, didn't present any evidence. For instance, there was a case in the Reyes case. In that case, it involved the Latin Kings. And in that case, the state called a police officer who testified in broad strokes about the evil of gangs and how gangs have criminal propensities and those sorts of things, and the court condemned that. But we don't have that. We don't have a reference to a word gang. We don't have any evidence. The state did not present any evidence to show that Mr. Shorter had a propensity to violence because he was a member of the gang, or that he had committed other acts of violence or even other acts of crime as a result of the membership of his gang. Didn't try to point to any prior criminal activity of the gang that Mr. Shorter may or may not have been involved in. Those sort of things that would have been prejudicial. Would it make any difference
if this gang was the Latin Kings?
Well,
and there hadn't been the preamble about gang violence by the police officer?
I don't think so. As I say, it's the state's position. I think there would be a stronger argument on appellant's part that everybody would know that that was a gang. than the 773 boys. But other than that, it's the state's position that gang membership, including reference to Mr. Shorter as a member of one gang and Mr. Green as a member of another, was relevant to motive. But in any event, any notion that the prosecutor's motive was sinister, is belied by the fact that motive was relevant. It was necessary in this case. This was a cold case. This murder happened in 2001. Mr. Shorter wasn't arrested until 2005, and the trial wasn't until, I think, 2008. So this was a cold case, and the prosecutor strictly limited in accordance with the trial judge's admonitions not to make it a feature of the trial. That's what he did. It was relevant. This court should affirm.
May it please the court. I think the case where gang references would be relevant is the Milan case cited by the state in its brief. And in Milan, the victim had a Latin king's insignia carved into his forehead. And obviously in a situation like that, when the defendant himself in that case admitted that he committed the crime but said it was in self-defense, that would be relevant, and that's something that can come out. In this case, and I think Judge Taylor said it the best, and I rely upon her analysis, if this is prejudicial, gang references or 773 boys references can be prejudicial. The question is, when you do the Wayne analysis, is the state's right to present evidence to establish motive, does it outweigh any prejudicial value? Well, the proper Wayne in this case, and I think Judge Bateman initially had it right, and he was talked out of that initial correct opinion, is that you can get in the analysis about the groups having their fight. That's the motive. That's enough. You don't need the label in this case. At some point when we have close cases and juries are deciding people's lives, the state shouldn't be given the benefit of having this prejudicial reference when they didn't need that prejudicial reference. They didn't need that added label. They had their motive. They had their argument. They could argue that this was a fight from the night before. It was this group against this group. Mr. Shorter was mad because of that fight, and he admitted that previous evening that he was going to do this. That should have been enough. But just the risk that the jurors may have convicted him in a very close case solely on the fact that he's 773 boys, because members of gangs or 773 boys are more likely to commit violence. And in a close case, we're going to rely upon, or that's going to be the factor that tips the scales in our decision to find him guilty. That shouldn't be allowed. This case should not have had any label at all attached to it. It should have been based solely on the facts without that added label. I'd ask this court to reverse. Thank you.